Good morning. Thank you for joining us for the July installment of Bracewell's Environmental Essentials for In-House Counsel webinar series. As many of you know, we do these monthly as a quick update on timely issues in environmental law. I think already this year we've covered risk management programs, reg reform and infrastructure principles, suspension and debarment issues, as well as the NSR reform initiatives going on over at EPA with Jeff Homestead. Today, we are going to be talking about the intersection of bankruptcy law and environmental law and touch on, I think, 3 or 4 cases that are sort of the most interesting that have come out in the last couple of years and talk about what's notable about them. I'm joined today by my partner, Mark Dendinger from the Financial Restructuring Group. Mark has a particular focus in debtor-side restructurings in the energy sector, and I think will add a lot of insights to the discussion. So we're going to go through the slide presentation. If you have questions as we go through this, please type them into the comment box on your screen. We'll get to as many questions as we can at the end of the webinar, and if we run out of time, we can try to respond to those questions in a follow-up email. So thanks again for joining us. I think what we ought to do for the webinar purposes is maybe take a quick refresher on the inherent tensions between bankruptcy law and environmental law to sort of level set everyone, and then touch on those 4 recent cases and how those tensions have manifested themselves. Probably spend a little more time on the Veneco case and the La Paloma case because they're of greater interest, and then get to questions. So we'll start with sort of the Bankruptcy 101, and I'll turn it over to Mark.
Hey, good morning, everybody. Mark Dendinger. Thanks for joining the webinar this morning. A quick bankruptcy law refresher for folks who are not familiar necessarily with the bankruptcy space, is certainly how it interfaces with environmental law. Essentially, when you file a bankruptcy, a debtor in possession is created. The company is called a debtor in possession, and a bankruptcy estate is created. An automatic stay is imposed, so it precludes creditors and litigants from coming after that debtor while the debtor is in bankruptcy to exercise enforcement measures or collect on debts against the debtor. Importantly for today's discussion, the debtor's balance sheet is essentially split in half. So there are pre-petition liabilities of that debtor before the filing date of that bankruptcy, and there are post-petition liabilities. Ultimately, every debtor in possession has one goal in mind, which is to propose a plan of reorganization in the bankruptcy case. And that petition date becomes eminently important because essentially any co-op liabilities of a debtor that are pre-petition liabilities, the result of that plan getting confirmed by that bankruptcy court is those debts are essentially extinguished or generally extinguished through the bankruptcy. Post-petition liabilities, those who provide goods to a debtor for the debtor to run its business and provide benefit to the estate, are paid 100 cents on the dollar in the case. It's black letter bankruptcy law. Every debtor, every Chapter 11 case is the same in that regard. But a debtor on its pre-petition debts and liabilities can compromise those claims and discharge them and offer them cents on the dollar as part of the plan. Very important for today's discussion. There's another case that comes up in the context of pre- and post-petition liability, this Atlantic case, which we'll discuss in greater detail as we go through the slides. Essentially, a debtor, one of the powers a debtor has in the bankruptcy is it can abandon property as part of its bankruptcy case. If the debtor has something it thinks of value and tries to run a marketing process and can't find a buyer of the asset through the bankruptcy, the debtor, through the bankruptcy case, can abandon that property so long as the court finds that it's burdensome or of inconsequential value to the debtor, unless there's a Mid-Atlantic situation, and that's the environmental piece. The Mid-Atlantic case was a Supreme Court case that essentially ruled that a debtor could abandon property in the bankruptcy so long as it didn't violate state law that's reasonably designed to protect the public health or safety from identified hazards, or in the alternative, in the face of a state law violation, the violation that the debtor is committing is not causing an imminent and identifiable harm. That's the standard the court holds a debtor to be able to essentially abandon what otherwise could be construed to be an environmentally contaminated property. As Jason said at the beginning, moving on to the next slide, the environmental issues in the bankruptcy, there's really a tension between bankruptcy law and environmental law. As I'd suggested, in bankruptcy, a debtor effectively wants to crystallize its liabilities as quickly as possible, propose a plan to discharge as many obligations as possible, and move out of bankruptcy during a short window of time with a fresh start. That's a difficult objective to achieve in the context of an environmental bankruptcy. Environmental law, as folks on this phone well know, long-term liabilities like monitoring, remediation, plugging, and abandonment obligations aren't co-ed liabilities or co-ed obligations of a company. They remain unknown for long periods of time, and so it becomes very difficult through a bankruptcy case to put forward a plan that ultimately tries to discharge those types of obligations of a company. There's a slide here talking about pre-petition, post-petition obligations of an environmental debtor. Essentially, there are a couple of tests that courts have derived to get comfortable with the sticky situations. Cleanup obligations is an example that we have raised. So the monetary obligations are pretty easy. If you can crystallize or make co-ed an obligation of the debtor as of the petition date, it's easy for the court to approve a plan that fixes that claim and pays money on account of that obligation or liability of a debtor. Cleanup obligations are very sticky issues. Essentially, these cases would say, under either test that we've put forward here, there needs to be some sort of pre-petition relationship to that company in order for the court to get comfortable that the obligation, the environmental obligation, could be characterized as a pre-petition claim of a debtor, ultimately subject to discharge. If you can't get through that threshold of clearance with the bankruptcy court will have a hard time characterizing key environmental obligations as items subject to discharge through your bankruptcy. We cited a couple of general examples here. I don't know, Jason, if you'd like to say a little bit more about some of these.
Well, so the examples are site conditions oftentimes could be discharged, but as a practical matter, if you're purchasing the property, the discharge of that obligation doesn't help you entirely under environmental law because as the current owner operator of the property, you may have responsibilities for the conditions at the site. Cap and trade surrender obligations, I think, are an interesting question because the emission event and the surrender obligation are separated in time and could be, you could have in between those two events, the filing for a bankruptcy in La Paloma is one such example. The Mid-Atlantic situation you covered already. Channeling injunctions is really an example of where like toxic tort claims, where a group of claimants, of potential or unknown claimants, the amount of money is set aside, and then any claims against the estate in the future have to go through that channeling injunction. Continuing non-compliance, as folks on the phone would know, environmental law gives rise to penalties on a per day per violation basis. So even if the debtor is out of compliance or the assets operated by the debtor are out of compliance at the time that the bankruptcy plan is confirmed, then the new owner or operator is out of compliance the moment they take over, and so they have those issues going forward. And that's also true for injunctive relief, right? In a lot of our enforcement documents, we see like consent decrees where there are going forward obligations. The environmental agencies are unwilling to allow a new owner operator of that facility to shirk the injunctive responsibilities that have been agreed to in a prior settlement. So those are kind of interesting questions as to whether those obligations get discharged. So let's jump into the four examples, and I suspect that we'll only find time to discuss mostly Veneco and La Paloma, but the slides will cover those and certainly be made available afterwards. But Veneco is an interesting one, filed for its second bankruptcy in April of 2017 in Delaware. Veneco is an independent E&P company with operations out in California, both onshore and offshore. They had gone through a previous reorganization in March of 2016 that was precipitated by the breach of the Plains All-American Pipeline 901. That was the Santa Barbara oil spill that folks are probably familiar with. But that was the artery for one of Veneco's sort of major assets, which was an offshore platform on state of California lands. And the emergence from the first bankruptcy was predicated on the optimism that that line would either be repaired or an alternative route to market would be found. And those who took the company out of that bankruptcy were willing to sort of stem the tide until the regulatory solution could be found to reconnect the asset with the market. Eventually, the land commissioners in the state, and this is just a citation to a news story, but the land commissioners sort of changed their position and said that they believed that the efforts to reconnect the project were dead, and that precipitated a second bankruptcy filing in April of 2017. This was a different sort of bankruptcy because basically it was a Chapter 11 plan of liquidation. And so that caused some very interesting issues from an environmental standpoint. And they're listed here, and we'll go through them one by one. But the first was the pre-petition quitclaim of offshore leases to the state of California. That's the leases associated with the platform that was once connected to the Plains All-American Pipeline. The second is the post-petition surrender of onshore and offshore leases, and as well as the abandonment of the offshore and onshore pipelines and the treatment of decommissioning obligations. So let's talk about each of those sort of in turn. The first is that Veneco held these leases offshore state of California and wanted to find a mechanism to basically get the most favorable treatment for its decommissioning obligations. And the leases provided for a unilateral quitclaim of the lease by the leaseholder, which Veneco did on the morning of April 17th out in California, effectuated that quitclaim, and then filed an hour later for bankruptcy in Delaware, so that the quitclaim event would be a pre-petition event, and position the company to argue that the claims, environmental obligations associated with the leases were pre-petition claims. The other side of that coin was that the company at the same time didn't want to create a mid-Atlantic type situation and had been in dialogue with the state agency for some time before actually quit claiming the leases, so that a safe transition of operational responsibility could be accomplished, essentially through a reimbursement agreement where, as of the date of the quitclaim, the company's employees remained on the platform for several months, and the state of California reimbursed the expenses of that continued operation until the state of California could get a contractor in place to perform the obligation. So it was a coordinated measure with extensive dialogue that's helped to sort of avoid any concern over an unsafe situation, and then the timing of the quitclaim just before the filing of the petition that I think were unique to this bankruptcy, but an interesting way of navigating the construct that you laid out in the Bankruptcy 101 slides. The next was, the second issue was the post-petition surrender of onshore leases. So Veneco also had for, I think 30 years or so, had an oil and gas rig on the Beverly Hills High School campus. This is actually a oil and gas platform of some notoriety. But the lease, interestingly, had terminated production on the 31st of December of 2016 and required that decommissioning take place within 90 days. And the lease did not have what a lot of oil and gas lawyers are accustomed to seeing, which is an habendum clause, which allows you to continue production for so long as the wells can produce in commercial quantities. And so that gave rise to several interesting questions, including whether or not an oil and gas lease without a habendum clause is an executory contract. But the more public fight was really over whether Veneco could simply sort of, quote, toss the keys to a shut-in oil well that a school district that lacked experience or expertise to manage those risks. And that came down to an in-court fight in Delaware, where Veneco had to put on testimony to basically satisfy the court that an orderly transition could be accomplished, and that a shut-in oil and gas well posed no imminent or identifiable risk, and that really what this was about was the school district finding a third-party contractor that were readily available to serve in that role and sort of take over the responsibilities of monitoring a shut-in situation. So that ultimately was where the court sided. The school district and the city of Beverly Hills appealed that decision, and a full and final settlement agreement was eventually reached among the parties. But the responsibility for operating the well site itself was transitioned within 2 months from the debtor to the school district. Mark, why don't you cover the third and fourth here?
Sure. A couple other interesting issues from an environmental perspective that came up. Issue number 3, onshore pipeline abandonment and contract rejection. In addition to owning onshore and offshore wells, having leasehold interests rather in onshore and offshore wells, Veneco owns certain onshore pipeline segments or otherwise in the bankruptcy. And ultimately, given that the company was no longer going to be operating its business, it obviously no longer had a need for owned pieces of pipeline to push production through that it no longer would be producing. So a couple issues came up in the bankruptcy a couple of pipelines. One was the Whittier pipeline. One was a pipeline called New Line 96. Effectively, the same fight in the bankruptcy was made manifest before the court. The issue became whether or not Vinico, prior to seeking an abandonment order from the bankruptcy court, had completed the decommissioning and de-inventory work for the pipeline and left it in what's called a Mid-Atlantic-proof state. In other words, in a state that didn't create imminent or identifiable harm to the public at large. Went through a couple of contested matters. The company went through a couple of contested matters similar to the Beverly Hills dispute that Jason had outlined, a little shorter in duration, and ultimately obtained abandonment orders from the bankruptcy court with regard to the abandonment of those two segments of pipeline. That folds into issue number 4 and effectively paved the way for the company to propose a consensual plan of liquidation, in this case in the bankruptcy, starting in late December of 2017, essentially 5 months before the company was able to put forward and ultimately propose that consensual plan. The company had started discussions with the remaining key environmental creditors in the case. These were legacy holders of assets that had sold the assets to Vinico that now ultimately had a prior possessory interest in the asset post-abandonment from Vinico and had claims against the debtor on account of that prior ownership of that asset. These were the federal regulators that were holding the feet to the fire to Vinico and ultimately to others to perform the decommissioning work essentially that needed to be done after the bankruptcy concluded and after Vinico was long gone. These were surety bond providers to the company that had written some of the surety bonds and provided some of the adequate assurance to the federal government and the other regulators, the state governments, ultimately that were required for Vinico to hold to be a counterparty to the federal and state oil and gas leases that it was counterparty to. Essentially 10 or 12 key creditors, all environmental creditors in the case. And Vinico came to the creditor base and essentially said, listen, we could do this the easy way or the hard way. The easy way would be for us to all effectively agree that claims for decommissioning obligations against the debtor would be treated as general unsecured claims against the debtor, essentially pre-petition claims that the debtor could ultimately effectively compromise through a bankruptcy plan, offer some monetary recovery on account of those claims, permit the debtor to propose a plan and exit bankruptcy. That would conserve cash for the debtor, ultimately provide some recovery to those claimants, and would be the best for both sides. The hard way would have been to have the same Mid-Atlantic battle with every individual creditor in the bankruptcy case and stretch out what otherwise was probably a quick, relatively speaking, year-long bankruptcy into a multi-year escapade with expensive fights on decommissioning claims and obligations before the bankruptcy court. Ultimately, through months of negotiation and twists and turns through a plan, got the decommissioning claimants comfortable with the terms of the plan being proposed. Vinico put it forward and got it confirmed before the bankruptcy court in May of this year.
I think just one of the other things that's notable about that fourth piece is that not only were I think some of the legacy owners looking at what the upside was of whether or not to litigate that claim in this particular situation, but what the downside might have been given the Mid-Atlantic rulings that they'd already seen in the case for future cases where, legacy liabilities, decommissioning liabilities came to roost and creating precedent in this situation.
Yeah, that was very important. One of the key components of the disclosure statement aspect of this plan, we had to agree, or rather the debtor had to agree ultimately to put language into the disclosure statement that was very crystal clear that these were unique circumstances. These cases were not to be held against these decommissioning claimants in future bankruptcies because they really didn't want to set negative precedent against the debtor where there maybe were some real assets against which they could ultimately recover.
Yeah. Okay, let's turn to La Paloma. Why don't you set the stage a little bit on this one?
Sure. So La Paloma Generating Company filed for Chapter 11 bankruptcy in December of 2016. La Paloma was a power plant owning debtor. They owned a natural gas-fired combined cycle electrical generation facility out in California. Ultimately, La Paloma filed for bankruptcy, citing issues with California's cap and trade program. Jason could probably speak to that a little bit more as we get deeper into the slides, but essentially La Paloma had emissions obligations under the program, under the cap and trade program, where effectively they were required to purchase and surrender emissions credits to the state in exchange for the carbon that was emitted by the plant in operating the plant. This became the key critical environmental ingredient of this bankruptcy, simply because La Paloma filed for bankruptcy under heavy debt load, under cap and trade regulations and regulatory constraints, and wanted to find a third-party buyer to sell the plant. They put forward a bid procedures motion, as all debtors do when they're looking to sell an asset through a bankruptcy case. Ultimately ran a marketing process. I think they found 170 or 180 interested parties, signed up a bunch of NDAs, gave a ton of folks access to the data room. But ultimately, what became problematic for the debtor's effort to sell the plant successfully to someone outside of the existing capital structure was the cap and trade program and the regulatory hurdle that one would need to clear in order to get comfortable that they would own the plant and how those emissions obligations would be treated in the bankruptcy court. And through the bankruptcy case, through a 363 sale process, effectively the question became whether the debtor could sell the plant free and clear of the debtor's existing emissions obligations. And it was interesting because, again, we come back to the pre and post petition bifurcation of the debtor's balance sheet of assets and liabilities. There was a ton of carbon emission, obviously going on before the company filed for bankruptcy. Then there's a post petition period where the question early in the case became, would those emissions obligations be treated like regular old administrative claims of the debtor? Would the debtor have to pay through a plan 100 cents on the dollar of the post-petition's emissions obligations, when really the debtor owning the plant didn't have a surrender obligation with regard to those emissions obligations until months after the bankruptcy was filed, 11 months after the bankruptcy was filed. All these issues had taken center stage in the case.
But all on the backdrop of the CARB program, which expressly says that if there's a sale of a plant during the triennial period for the accounting of the surrender obligations, if that sale occurs, the new owner on the surrender date is responsible for the surrender of credits for the entirety of that period, not just their ownership period. So, and that preserves, obviously, California had designed that to preserve the integrity of the cap in the cap and trade program. So here you have a situation where a plant emits many tons of carbon or carbon dioxide over a period of time, files for bankruptcy, continues to run and emit carbon dioxide during the pendency of the bankruptcy. The bankruptcy is finalized. A new owner, L&B, emerges and wants to know if it can extinguish the surrender obligation that comes during their period of ownership, but relates back to the emissions that occurred both pre-petition and post-petition. And that's what then the fight was over tens of millions of dollars related to that. But I think also California was not just fighting about the surrender of the credits, but also the integrity of the cap and trade program itself.
Yeah. And L&D was the existing first lien lender. So coming full circle back to the difficulty the debtor experienced in trying to market the asset and sell it to a third party. Effectively, the first lien lender came into the bankruptcy and said, we'll take it. And through a feature of bankruptcy law where they can set off against the purchase price any pre-petition debt they were owed as of the time of the filing, they effectively bought the plant by surrendering their secured debt through the bankruptcy. We've got a slide here laying out the arguments that both sides made with respect to the dispute that unfolded in the bankruptcy court surrounding whether or not the cap and trade emissions obligations were something that was construed to be an interest, which under 363 law in the bankruptcy case ultimately was the feature that would permit the debtor to sell it free and clear of that interest to a new buyer, in this case, L&B. You can read through the arguments there. But ultimately, the court came down on the side of the debtor and said that these emission obligations did indeed qualify as interest under Section 363 of the Bankruptcy Code, specifically subsection F, and pointed ultimately to an issue that existed in the underlying regulatory scheme and the law. There was not a successor liability clause in the underlying applicable state law. And so for that reason, as well as the fact these were construed to be interests by the bankruptcy court, the court ultimately got comfortable that L&B as the new owner could own the plant free and clear of these obligations.
Yeah. And then, of course, California went back to the drawing board and started working on new legislation to be sure that they clarified their expectations under the cap and trade program. We have about 5 minutes left, so why don't we skate through these other two cases in just a minute or two and leave a little bit of time for questions. I know we've got at least one question, but the Philadelphia Energy Solutions case is another cap and trade regulatory framework with the renewable fuel standards obligations, where refiners are required to either blend biofuels into their products or buy credits for those from those who do. And this was a very significant factor in Philadelphia Energy Solutions eventually filing for bankruptcy, and sort of became a political hot potato here in Washington about the RFS program. But associated with that was whether or not PES could get any relief from EPA for the obligations that had arisen from its pre-petition refining, and whether they would have to have credits to surrender. And ultimately, a settlement agreement was reached with EPA where they were only required to surrender the credits that they already held, and they avoided several $100 million in surrender obligations that were associated with those operations. I think it was about $200 million. So let's, why don't you tee up Fieldwood Energy too?
Yeah, Fieldwood, the important thing there, this was a very quick Chapter 11 filing down in Texas. These were Gulf of Mexico assets. Essentially, the debtor Fieldwood, as part of its plan exercise, wanted to buy up a ton of Noble Energy's deep water assets through the bankruptcy case, and raised a bunch of money through a rights offering through the bankruptcy, and effectively was successfully able to purchase those assets through the bankruptcy. I think what's important here is it's important for an environmental debtor to always keep the regulator involved in the discussion. These sale processes are inflection points for, in this case, the federal government, Bureau of Safety and Environmental Enforcement, to come in and ultimately approve the debtor's adequate assurance of its ability to future perform on the assets they're buying and fund the royalty payments to the government, et cetera. And so they require financial assurance from these debtors. It can be in the form of surety bonds like Beneco essentially had put forward. It can be other forms of credit support. They can raise and lower the amount of credit support that's ultimately required. And again, a sale process through a bankruptcy is an inflection point that creates one of these discussions with the regulator. Ultimately, the regulator got comfortable with the sale and approved it with the condition subsequent that they could ultimately pass muster on the financial assurance that Fieldwood was putting forward.
Yeah, with much more significant dollars at stake from a decommissioning liability standpoint than what we saw in Beneco. So interesting situation. Okay, so I'll do one question and then we can get to the others offline. But the question was, are these issues unique to the specific circumstances of the debtors, or do you expect to see them manifest in future cases that we should be watching?
Yeah, I'll take a shot at it. I think they are unique and not unique. I suppose they're unique insofar as these cases are very factually specific, as we've just outlined. And so it's always unique to the debtor. It's a very factually driven exercise in a bankruptcy case. Whether it's an energy case or a retail filing or a healthcare filing, it doesn't much matter. I think it's general and could be applied to future bankruptcies in a couple of ways. Certainly the narrow ruling that Beneco achieved in its bankruptcy on Mid-Atlantic issues and its ability to safely abandon assets, pipelines, and surrender leases in compliance with the bankruptcy code and not in violation of the Mid-Atlantic standard is something that could be brought to bear in future bankruptcies. I think the regulatory, the other way in which these things are general and could be put forward in future bankruptcies, you look at the cap and trade type landscape that existed in La Paloma and in other environmental cases. I think those types of regulatory issues could be brought to bear in future bankruptcies, and whether it's a specific cap and trade program by California or another state government's emissions obligation program, these things are general issues environmental-wise that could come forward in future cases, whether it's a reorganizing debtor that wants to reorganize and deleverage its own balance sheet, whether it's trying to sell its assets as La Paloma did to a third party and triggering discussions with regulators, or whether, unfortunately for Beneco, it's a wind down exercise. These issues could come to light.
The one thing I would add is that I think the Beneco sheds further light on how narrowly the Mid-Atlantic decision or the Supreme Court will be interpreted, particularly in the context of decommissioning obligations, whether those related to pipelines or oil and gas upstream assets. But it does begin to shape that there's not necessarily a Mid-Atlantic situation when a pipeline holds oil or a platform is shut in. And I think that's important for future cases. So we've run out of time. Thank you, Mark, for joining us for the webinar this month. We appreciate everyone who's taken the time to join us from near and far. If you've asked a question that we didn't get to, we will reach out to you after the webinar. If you have additional questions or want to discuss anything that we talked about today further, please feel free to reach out to us. Our contact information is on the last slide. I know that the presentation with the audio and the slides will be posted to the Knowledge Center on Bracewell's website shortly. If you'd like it sooner, shoot us an email. We're happy to send it out to you. Thanks, everyone. We look forward to talking to you next month about another topic. If you have topics that you'd like to hear about from us, please also submit those ideas. We're happy to cover those as part of our monthly webinar. Have a good day.